Thank you, Mr. Chairman, committee members. My role tonight is in the background of this legislation, which actually goes back all the way back to 2008, and we work with a number of stakeholders, including the Family Life Center, now Open Doors, to take a look at the way in which court costs, fines, fees, assessments, and restitution are assessed and collected in criminal cases. So I gave you a summary of that legislation from 2008. You'll see it amended a number of different provisions of law relating to this very issue. And the legislation sought to do a couple of things. First, to reinforce the court's authority, the inherent power that the court has in appropriate cases, not a blanket authority to do so, but in appropriate cases to waive some or all of the court costs, fees, and assessments that are mandated in just about every single criminal case. And the legislation also said that restitution to victims should not be touched, should not never be waived, and also when money is being taken in by the courts, that victims get paid first. They get made whole first whenever there is a restitution order entered. So in putting that legislation together, what we did, what I can remember from it, was to look at a way to streamline the process, to make it easier for judges, clerks, and whoever's responsible for assessing and collecting these fees to be able to make a quick and easy and reliable determination about a defendant's ability or inability to pay. What we came up with was really two different things. Number one, we named a number of government entities that, acting under color of law, in some cases federal law, in some cases Rhode Island law, their determination that someone was indigent was not a determinative factor, but an important factor that ought to be considered by a judge when making a determination of ability to pay. So as I recall, we put in things like, unemployment. It's in your testimony, in the written materials that gave you. And so what that does is a judge would start with the proposition that I can presume this person does not have the ability to pay all this money up front, whatever it might be, if they're receiving government benefits, and that government entity, acting under color of law, made that determination that the person was indigent. One of the things this legislation does is also adds, the public defender acts under color of law 12-15 in making a determination if our clients are eligible or not. So we thought it might make some sense to add that. But that clearly is not the most important part of the legislation. The other thing that the 2008 legislation did was to create this thing called a financial assessment instrument. And what that really is I believe it says under accepted accounting principles, etc. And that a clerk can easily, or a judge can easily go through these things and within a minute or two have a pretty reliable determination about this person's ability to pay. And that's really what it was about. How did the legislation come about? Well, there were really two things that caused this legislation to be enacted. The first was we were able to engage in a conversation and we know the answer to this. We knew the answer then and we know it now. If we're locking up people because they don't have the ability to pay, how much money are we getting out of them? And putting that in one pile. and then saying how much money is being realized from detaining these people. And we know that's an argument that we win every single time, because it's expensive to put people in prison, keep them in prison. $40,000 a year, depending upon what part of the ACI that you're in. The other thing that drove this process in 2008 was some fabulous work that was done by the Family Life Center, now Open Doors. I think Nick Horton's going to talk about their work in that regard, the report they prepared. I think it's still up on their website, which really did, you know, the hard work that was necessary in making these conclusions and these determinations. Lastly, there was a young lady who worked on this. I can't remember her name. I think she's in the room. I don't remember. Who did some great work as a graduate student at Brown University and just wrote a fabulous, reliable report that's easy to understand. Even I understood the executive summary. And, you know, you folks should look at that and see why something like this is a good idea. So why do we need to tweak it? Why do we need to tweak these things that were done in 2008? So the witnesses are going to follow and address that a little bit better than I can. But I think the thing that got our attention was more anecdotal. And that is, a year or two after this was enacted, and I continue to do this periodically, I asked my brothers and sisters through our listserv, has anybody been present when one of these financial assessment instruments has been filled out by the clerk? Or has anyone seen a judge do it? And I got all negative responses except one. And that was, I don't recall who the judge was, but there was one who was using it after the person was brought in, after being arrested for failing to pay. So, what this legislation does, simply stated, at the end of a criminal case, the judge is required to enter a judgment. The judgment is an order of the court saying what the sentence is, how the person is supposed to be punished, and also how much they have to pay. The meat of this legislation says, gives effect to what you folks did 11 years ago by saying you can't enter one of these orders unless you do one of these financial assessment instruments. That's the bottom line of this. That's the part that makes the most sense. Because they ought to be doing what you folks told them to do 11 years ago. And again, it was designed to be a streamlined process, easy to do, check off the boxes, require the defendant to fill it out or not, require additional proof, whatever it is. But these are things that ought to be done, that to our way of thinking, are not done. So, with that, I'll try to answer any questions you might have.
So who would make the assessment?
So it depends on what court you're in. And generally what should happen is, what happens at the end of a criminal case in Superior Court, for example, they take the person, fills out the papers. Let's say he's getting probation or suspended sentence. He's not in prison. He's going to go in the back and he's going to sign all these papers, or she's going to sign all these papers. And then it's off, you know, they make arrangements to pay. What we hear is that that process is not being done. And like I said, there are others who can speak to this issue better than I can.
But who makes the financial assessment that they make?
Should be the clerk of the court. A clerk of the court.
Would that take time outside of the court? In other words, can they do it right there, or?
Sure, they could do it in court too, according to the 2000. I mean, the judge could do it. We've heard of one judge doing it when someone gets arrested because they didn't show up for an ability to pay hearing or whatever, and then they're arrested and brought in. We have heard of one example of a judge doing it.
And would any paperwork or documentation be involved?
Sure. Yeah, there would be this financial assessment instrument, which is about a page. There actually is one on the court's website.
Part of the defendant.
Would the defendant be required to fill it out?
No, not required to fill it out. Required to provide financial statements.
They could. But they could.
It's not required.
No.
So, for the most part, it would be an on-site evaluation by the judge or the clerk.
It could be, yes.
Okay.
To follow up on Dr. Kavasi's question, in this case, I'm assuming in order to qualify for a public defender, there had to have been some sort of financial assessment and things presented. So this is actually bringing a portion of the paperwork that you're asking about to the table. If this would be passed, at least there would be some aspect that the defendant would have had to have provided this information in order to qualify for public.
Yes, and the kind of prima facie evidence of indigence, right? I'm talking about the lawyer, right? Prima facie evidence of indigency, there are already a number of factors, like one, I think one is SSI, you can see what they are. We just asked one more we added, and that's qualification for our services, which, by the way, we're required to do by law. And there's actually, in our statute, there's a definition of indigency that we're asked to apply to each and every one of the 27,000 referrals that we get.
Any further questions? Yes.
Thank you, Mr. Chairman. So, Mr. DeLauro, my question is, the other criteria that's noted in this bill is public assistance, disability insurance, food stamps. The difference between the people that qualify for your services is many of them are capable of getting a job, and the courts generally give people a good amount of time if they keep coming back to say, for whatever reason, they can't pay, as we know. So why, I'm just questioning why you think that because they're indigent at that time, doesn't mean they're indigent forever.
Oh, absolutely, you're absolutely right.
Yeah, with some of the other criteria could mean a disability insurance, maybe it's harder to get a job. I don't know what the disability would be, but...
And again, what the important part to remember, though, Rep, is that the waiver by a judge, if that's what is requested, is never mandatory. You can't do that. And it's just, we think that this is a valuable tool that ought to be used the way you folks said it should be used. And, it's very carefully put together so that to make it as least administratively burdensome as possible. You say, show me your social security, your proof of your social security, for example. Well, that's it. You've got prima facie evidence of indigency at that point. Does that mean everything should be waived? No. Maybe the person ought to bring in $10 a week or $10 a month.
Right.
Judge determines that. We think that having that information made available in every single case, it made sense in 2008, and it makes sense now. And
well, it's just like many of them are on probation, and the probation officer tries to help them find a job so that they can pay their court costs and the restitution and the fines,
yes.
right?
Yes.
So, that's part of being on probation, isn't it?
Well, there is, and there is costs imposed for being on probation.
Right.
Everything
costs now, right?
Well, we have a user fee system of criminal justice in this state. I've said that for years. That might be a good thing or it might be a bad thing, but it's just the way it is.
Thank you.
You're welcome.
Okay, the next witness is Elizabeth Seaver.
Excuse me, Chairman. Dr. Mocking.